If you're planning to apply for a U.S. visa, adjust your immigration status, or travel to the United States in 2026, what I'm about to share could completely change your plans. Major policy shifts have just taken effect this month, and thousands of visa applicants are already being impacted. Some are facing unexpected delays, others are seeing their applications placed on hold, and many don't even know these changes exist yet. Stay with me because by the end of this video, you'll know exactly what's changed, who's affected, and most importantly, what you need to do right now to protect your immigration plans. Welcome back to Entry Status USA, your trusted source for accurate, timely immigration information. I'm here to help you navigate the complex world of U.S. immigration law. And today's video is particularly important. We're in February 2026, and the U.S. immigration landscape has undergone some of the most significant changes we've seen in recent years. From the February visa bulletin that just dropped to new H-1B lottery rules taking effect next month. From expanded travel restrictions affecting 39 countries to processing holds that could delay thousands of applications. There's a lot to cover. This isn't clickbait or speculation. Everything I'm sharing today comes directly from official government sources, including the State Department, USCIS, and recent federal regulations. If you find this information valuable, please hit that subscribe button and turn on notifications. Immigration policies are changing rapidly, and I want to make sure you never miss a critical update that could affect your future in the United States. Let's dive in. Section 1. February 2026. Visa Bulletin, Employment-Based Categories. Let's start with some good news for many of you. The Department of State just released the February 2026 Visa Bulletin, and there's significant movement in certain employment-based categories, particularly for EB-3 applicants. This is the bulletin that determines when you can file your adjustment of status application or when your immigrant visa interview can be scheduled. Before I dive into the specifics, let me explain what the Visa Bulletin actually is and why it matters so much. Every month, the State Department publishes this bulletin to regulate the flow of immigrant visa applications, because there are annual limits on how many immigrant visas can be issued in each category. And for each country, the bulletin uses priority dates to manage who can apply when. Your priority date is typically the date that your labor certification was filed, or your I-140 immigrant petition was received by USCIS. Now, here's what you need to know for February 2026. USCIS has announced that they will continue to use the dates for filing chart for employment-based adjustment of status applications. This is important because the Visa Bulletin actually contains two charts, the dates for filing chart and the final action dates chart. The dates for filing chart is generally more favorable because it allows you to file your application earlier. The final action dates chart is what determines when USCIS can actually approve your application and grant you permanent residence. Each month, USCIS decides which chart to use for filing purposes. For February 2026, they're using the dates for filing chart, which means you should check your priority date against that chart to determine if you can submit your I-485 application this month. This decision by USCIS is significant because it shows they have sufficient visa numbers available and are trying to manage the flow of applications efficiently. The big story this month is advancement in the EB-3 category. For most countries, including Mexico, the Philippines, and what's called Rest of World or all chargeability areas, we're seeing movement of approximately 3 months forward in the dates for filing chart. This means if you've been waiting to file your I-485 application to adjust status, you might finally be eligible. This advancement is particularly welcome news because for many months during 2024 and early 2025, we saw retrogression in employment-based categories where dates actually moved backward or remained stagnant. Let me break down the specifics for each employment-based category. For EB1, the category for individuals with extraordinary ability, outstanding professors and researchers, and multinational executives, most countries remain current. When a category is listed as current, it means all applicants in that category can file regardless of their priority date. This is the best possible situation. So, if you have an approved I-140 petition in the EB1 category, and you're from most countries, you can file your adjustment of status application right now without waiting. However, if you're from China or India, there are some restrictions even in EB1. China's EB1 date remains at August 1, 2023, which means only applicants with priority dates before that date can file. India's EB1 remains current for February, but this could change in future months depending on demand. The reason China and India often have different dates is due to the per-country limit. No single country can receive more than 7% of the total family-sponsored and employment-based visas in any year. Because India and China have such high demand for U.S. immigrant visas, they frequently hit this per-country cap, creating backlogs. For EB2, the category for professionals with advanced degrees or exceptional ability, the situation varies significantly by country. This category includes people with master's degrees or bachelor's degrees, plus 5 years of progressive post-degree work experience, as well as individuals who can demonstrate exceptional ability in the sciences, arts, or business. India and China continue to face the longest backlogs in EB2 due to the high volume of applicants from these countries. For India, the EB2 category shows minimal movement this month. For China, EB2 has remained relatively static as well. However, for EB3, which covers skilled workers and professionals with bachelor's degrees, this February bulletin represents meaningful progress for applicants from countries other than India and China. The EB3 dates for filing chart has advanced by approximately 3 months, and the final action dates chart has moved forward by about 5 weeks. This is significant because it means thousands more people are becoming eligible to complete their green card process. Why is this advancement happening now? According to immigration law experts, it's likely due to a combination of factors. First, the decreased number of H-1B registrations for fiscal year 2026 may have reduced the pipeline of future EB2 and EB3 applicants. Second, USCIS has been processing adjustment of status applications more efficiently in recent months. Third, there may be unused visa numbers from other categories being recaptured and reallocated to EB3. One critical note about a specialized subcategory, the EB4 Certain Religious Workers category, also known as SR, has become unavailable for all countries as of February 2026. This is because the program sunset on January 30, 2026, as the congressional authorization expired. If you were planning to apply under this category, you needed to have your petition filed and the visa issued before January 29, 2026. Any visas issued before that date were only valid until January 29, 2026, and all individuals seeking admission had to be admitted into the United States no later than midnight on that date. The program may be extended by Congress through new legislation, and if that happens, it would likely become available effective immediately. But as of right now, in February 2026, it's unavailable. If you're a religious worker or an organization that sponsors religious workers, you need to monitor congressional activity closely to see if this category gets reauthorized. Section 2. Family-Based Visa Bulletin. Now, let's talk about family-based immigration categories. The February 2026 Visa Bulletin shows that the annual limit for family-sponsored preference immigrants is 226,000 for fiscal year 2026. The per-country limit remains at 7% of the total annual family-sponsored and employment-based preference limits, which comes out to 25,620 visas per country. For family-based categories, the movement has been more modest compared to employment-based categories. If you're a U.S. citizen petitioning for an unmarried adult son or daughter, that's the F1 category. Or if you're a permanent resident petitioning for your spouse or children, that's the F2 category. You'll want to check the specific dates for your country of chargeability. Mexico, the Philippines, India, and China often have different dates than other countries due to higher demand from these nations. The bulletin lists separate columns for these countries. So, make sure you're looking at the correct column for your situation. For immediate relatives of U.S. citizens, such as spouses, parents, and unmarried children under 21, there's good news. These categories are not subject to numerical limitations, which means there's no waiting period based on visa availability. However, processing times still apply. And that brings us to our next critical topic. Section 3. Diversity Visa Program Changes. If you've applied for the Diversity Visa Program, commonly known as the DV Lottery or Green Card Lottery, listen carefully. There have been significant changes affecting DV 2026 selectees, and you need to understand the timeline and limitations. First, the number of available diversity visas for DV 2026 has been reduced. Originally, the program allocates up to 55,000 visas annually. However, due to statutory requirements under the NACARA program and amendments made by the National Defense Authorization Act for fiscal year 2024, the DV 2026 annual limit has been reduced to approximately 52,000 visas. This is a reduction of about 3,000 visas from the original allocation. Here's what's absolutely critical for DV 2026 selectees. Your entitlement to immigrant status in the DV category lasts only through September 30th, 2026. That's the end of fiscal year 2026. After that date, no DV 2026 visas can be issued. Period. This deadline is absolute and cannot be extended. If you were selected for DV 2026, you need to act immediately if you haven't already. Submit your DS-260 immigrant visa application, gather all required documents, complete your medical examination, and attend your consular interview. The State Department has warned that visa availability through the end of fiscal year 2026 cannot be taken for granted, and numbers could be exhausted before September 30th. Additionally, on December 18, 2025, the Department of Homeland Security announced a pause on a portion of the Diversity Visa Lottery program. While this doesn't affect DV 2026 selectees who are already in process, it signals potential changes to future DV programs that applicants should monitor closely. Section 4. Major H-1B visa changes for 2026-2027. Now, let's discuss what might be the most talked about immigration topic right now, the H-1B visa program. If you're a professional seeking to work in the United States, or if you're an employer sponsoring foreign workers, major changes are coming, and some are already in effect. Let's start with the H-1B lottery system changes. On December 23, 2025, the Department of Homeland Security announced a final rule that fundamentally changes how H-1B visas are allocated. This new rule takes effect on February 27, 2026, and will be used for the fiscal year 2027 H-1B lottery, which opens for registration in March 2026. Here's how the new system works. Instead of a purely random lottery where every registration has an equal chance of selection, the new system implements a weighted selection process based on wage levels. Let me explain what this means for you. The Department of Labor establishes 4 wage levels for each occupation based on prevailing wage data. Level 1 represents entry-level positions. Level 2 represents qualified workers. Level 3 represents experienced workers. And Level 4 represents fully competent workers or specialists. Under the new weighted selection system, your registration gets entered into the lottery pool multiple times based on which wage level your offered position corresponds to. Specifically, if your offered wage qualifies as Level 4, your registration gets entered into the selection pool 4 times. Level 3 gets entered 3 times. Level 2 gets entered twice. And Level 1 gets entered just once. This doesn't mean you can't get selected if you're at Level 1, but your probability is significantly lower compared to higher wage levels. The Department of Homeland Security projects that this change will reallocate approximately 10,000 H-1B approvals annually from lower wage positions to higher wage positions. They estimate this will result in about $52 million more in wages paid to H-1B workers in fiscal year 2026, rising to over $2 billion annually from fiscal year 2029 through fiscal year 2035. Now here's the other major H-1B change you need to know about. In September 2025, the White House issued Presidential Proclamation 1973, which requires a $100,000 payment for certain new H-1B petitions. This fee applies to new H-1B applications filed after September 21, 2025, for beneficiaries who are outside the United States and who will be entering the U.S. on a new H-1B visa. Let me be very clear about what this $100,000 fee does and doesn't apply to. It applies to new H-1B petitions where the beneficiary is currently outside the United States. It does not apply to H-1B renewals or extensions for people already in H-1B status. It does not apply to change of status applications where someone is already in the U.S. on a different visa and is changing to H-1B status. And it does not apply to change of employer petitions for people already in H-1B status. The proclamation includes a national interest exception, meaning certain cases can be exempt from the fee if they serve U.S. national interests, but these exceptions are granted on a case-by-case basis and require careful documentation. The $100,000 fee requirement is currently set to expire on September 21st, 2026, 1 year after it took effect, but it could be renewed or extended. The H-1B registration period for fiscal year 2027 opens on March 4th, 2026 at noon Eastern Time and runs through March 19th, 2026 at noon Eastern Time. If you're planning to participate in the lottery, you need to register during this window through your USCIS online account. One more important point: the registration fee itself has increased. As of January 1st, 2026, due to inflation adjustments required by law, several immigration fees have gone up. You'll need to pay the current fee when submitting your registration. Section 5. Enhanced Vetting and Screening. Across the board, we're seeing enhanced vetting and screening procedures for immigration benefits. On December 5th, 2025, USCIS announced the creation of a new USCIS Vetting Center designed to centralize the enhanced vetting of applicants. This center is responsible for screening for national security threats, criminal activity, fraud, and other public safety concerns. What this means in practice is that more applications are being subject to additional administrative processing, security checks, and interviews. The State Department has also expanded its social media screening requirements. As of December 3rd, 2025, the online presence review requirement now includes H-1B workers and H-4 dependents. Applicants are instructed to disclose social media identifiers and ensure that their accounts are set to public visibility during the visa adjudication process. If you're applying for a visa, expect your social media presence to be reviewed. Make sure your social media accounts don't contain content that could be viewed negatively by immigration officers, such as statements suggesting intent to overstay, work without authorization, or engage in activities inconsistent with your visa category. Additionally, as reported on December 26, 2025, Customs and Border Protection began implementing a policy of photographing all non-citizens as they enter and exit the country. This applies to everyone who isn't a U.S. citizen, including green card holders and temporary visa holders at every port of entry. Section 10. Premium processing fee increases. If you're planning to use premium processing to expedite your immigration application, be aware that fees are increasing. On January 12, 2026, USCIS published a final rule in the Federal Register, increasing the filing fees for premium processing of applications and petitions for U.S. immigration benefits. The new fees take effect on March 1st, 2026. For example, premium processing for an H-1B petition will increase from $2,805 to $2,965. The fee to file Form I-765 for F1 optional practical training or the STEM OPT extension will increase from $1,685 to $1,180. These increases are due to inflation adjustments, and they're in addition to the base filing fees for the actual petitions and applications. If you're planning to file and can do so before March 1st, you can save money by filing under the current fee schedule. Section 11. Temporary Protected Status Terminations. For individuals from certain countries who have been protected from removal under Temporary Protected Status, TPS, there have been significant announcements. The Secretary of Homeland Security has announced the termination of TPS designations for Somalia and Ethiopia. Somalia's TPS designation termination will be effective on March 17, 2026. Ethiopia's termination date has also been announced. If you currently have TPS from either of these countries, you need to consult with an immigration attorney immediately to understand your options. You may be eligible to adjust your status through another pathway, or you may need to prepare for departure from the United States. TPS is meant to be temporary protection during crisis situations in home countries. When conditions improve or when the administration determines that the designation is no longer warranted, TPS can be terminated. It's crucial to stay informed about the status of your country's TPS designation, what you should do now. Given all these changes, let me give you clear, actionable advice on what you should do right now, depending on your situation. If you're waiting for Visa Bulletin movement, check the February 2026 Visa Bulletin on the State Department website. Determine whether your priority date is current under either the Dates for Filing chart or the Final Action Dates chart. If you're eligible to file, don't delay. Processing times are unpredictable, and the sooner you file, the sooner you'll be in the queue. If you're planning to participate in the H-1B lottery for fiscal year 2027, mark your calendar for March 4th through March 19, 2026. Understand the new weighted selection system. If possible, work with your employer to structure your position and offered wage to fall into the highest wage level you legitimately qualify for. This will increase your odds of selection. Be prepared for the registration fee and understand that if you're selected and you're currently outside the U.S., the $100,000 fee may apply unless you qualify for an exception. If you're from one of the 39 countries affected by the expanded travel restrictions or the 75 countries affected by the immigrant visa pause, you need specialized legal advice. Consult with a qualified immigration attorney who can assess your specific situation, advise on potential exceptions or waivers, and help you navigate the hold on your application. Don't try to handle this alone. The rules are complex, and mistakes can have serious consequences. If you have a pending application that might be subject to the USCIS processing hold, stay in close contact with your immigration attorney. Respond promptly to any requests for evidence. Maintain your status while you wait. Don't let your current visa or status expire while your adjustment application is pending. If you need to travel, understand the risks and get proper authorization before leaving the U.S. If you have an Employment Authorization Document, EAD, check your expiration date right now. If it expires in the next 6 to 9 months, start your renewal application immediately. Don't wait until the last minute. USCIS processing times have been unpredictable and you don't want to risk a gap in your work authorization. If you're a student on F1 status planning to apply for OPT or STEM OPT, file as soon as you're eligible. Don't delay. The processing holds affecting certain countries, and the enhanced vetting procedures mean processing times may be longer than usual. If you have approved immigration benefits and you're from one of the countries subject to re-review, document everything. Keep copies of all your approval notices, supporting documents, and correspondence with USCIS. You may be called for an interview or asked to submit additional evidence. Be prepared to demonstrate that you qualified for your benefit at the time it was approved and that you continue to comply with all requirements. For everyone, regardless of your situation, stay informed. Immigration policies are changing rapidly. Subscribe to this channel so you don't miss important updates. Check the official USCIS website, the State Department website, and consult with qualified immigration attorneys for personalized advice. Document everything. Keep organized files of all your immigration documents, correspondence, receipts, and evidence. Take screenshots of important information from government websites. Print out policy memos and guidance documents. If something changes, or if you need to prove something later, you'll have the documentation. And finally, manage your expectations. If you're affected by processing holds, travel restrictions, or other limitations, understand that this may take time to resolve. Be patient, but also be proactive. Explore all your options and don't give up on your immigration goals, but have realistic timelines and backup plans. We've covered a lot of ground today, and I know it's overwhelming. The U.S. immigration system in February 2026 is complex, and these recent changes have made it even more challenging for many people. But knowledge is power, and by understanding these changes, you're in a much better position to navigate them successfully. Let me recap the most critical points. The February 2026 Visa Bulletin shows advancement in EB3 categories for most countries. The H-1B system is changing with a new weighted lottery and the $100,000 fee for certain new petitions. Travel restrictions now affect 39 countries with processing holds on USCIS applications. Immigrant visa issuance is paused for 75 countries. EAD validity periods have been shortened. Asylum processing is on hold, and enhanced vetting is being implemented across the board. These are real policy changes affecting real people. If you're one of those people, I want you to know that while these changes create challenges, they don't eliminate opportunities. The United States remains a destination for talented, hard-working individuals from around the world. The path may be more complex now, but with the right information, proper planning, and qualified legal assistance, you can still achieve your immigration goals. If this video was helpful to you, please give it a thumbs up and share it with anyone you know who might need this information. Leave a comment below telling me which of these updates affects you most, or if you have questions about your specific situation. While I can't provide individual legal advice in the comments, I do read them all, and they help me understand what topics to cover in future videos. Make sure you're subscribed to Entry Status USA and hit that notification bell so you're alerted the moment I post new content. I monitor immigration news daily, and when there are important developments, I want you to hear about them immediately. Remember, this information is for educational purposes. It's not legal advice for your specific situation. Immigration law is complex, and every case is different. For personalized guidance, always consult with a licensed immigration attorney who can review your individual circumstances and provide advice tailored to your needs. Thank you so much for watching. I'm committed to keeping you informed with accurate, timely immigration updates. Until next time, stay informed, stay prepared, and don't give up on your American dream.